My name is Nathaniel Sperger, and I'm with the Women's Business Center. I think one of the best ways to interact with us here at the Women's Business Center is to schedule a one-on-one counseling session. After one of these sessions or before, schedule a one-on-one and talk to us about what you're doing with your business, whether you're starting, whether you're in the middle of it, whether you're growing your business, whether you're looking for funding. All those things are areas in which we can guide you or direct you somewhere where you can get guidance or resources or help. We are funded by the SBA, and we are under the National Institute, which also has a lot of programs designed around minority economic development and business ownership in general. So lots of good resources there. Check out our website, and through there you can get to the National Institute as well. I'm going to hand it over to Donna and let her take over and enjoy this time and throw out those questions, and let's connect with each other. Thank you, Donna.
Thank you. I'm so excited to talk to you guys about intellectual property. I have my own law firm, Legal Direction. I'm in year 7 of owning my own company and being an entrepreneur, and I love almost every minute of it. What I want you guys to get from this program is the ability to identify what kind of intellectual property you might have some understanding of how to protect it, what you can do, what you can stop other people from doing, and how to go about it. I will take questions that are related to that. You know, is this a trademark? Is this a copyright? Where do I go for more information? But this isn't really a good forum for you to discuss your specific intellectual property questions. A lot of intellectual property has some proprietary nature to it. We need some secrecy, and I'll get into that, but don't put anything in the chat that everybody can't see. Because you may need to have some non-disclosure agreements in place to share your information. I don't want you to lose any rights that you might have. And I'm going to take my camera off while I talk. All right, what is intellectual property? Intellectual property is the intangible asset of your company, your idea, your invention, your brand, how people feel about your business. And it always starts with a great idea. This slide is supposed to be the fireworks in your brain just going off because you have this great concept for a new business or a new process or a new product. There are 4 kinds of intellectual property: trade secrets, patents, copyrights, and trademarks. Patents and copyrights are protected in the U.S. Constitution. Gives Congress shall have the power to promote the progress of science and useful arts by securing for limited times to artists and inventors the exclusive right to protect their respective writings and discoveries. So patents and copyrights, the whole point of these is that you worked really hard to commercialize an idea that you had, whether it's an invention, a machine, a process for doing something, or a novel, or a photograph, or a statue. And as the artist, you should have, or the inventor, you should have some time to exclusively make money from your invention or your artwork. And then we're going to put it in the public domain so it can be an inspiration for other people and they can springboard off of your idea. So that's patents and copyrights, and to some extent trade secrets. Trademarks, you're going to find out, is a completely different legal framework. IP always starts with a trade secret. I have an idea. I have a new way to do something. I have a new machine to do something more effectively. I developed a recipe. I'm writing a novel. I have this new product, and here's how I'm going to brand it. It's always a trade secret at the beginning before you tell anybody. And then sometimes, sometimes it's also something else. So if your idea is a machine or a process, it's also going to be under patent law. If it's a creative endeavor, it's also going to be under copyrights. If it's your brand name or logo, it's also going to be a trademark. And this is normal. Software sometimes could be also trade secret, patent, and copyright. So don't get hung up on if it's a trade secret and something. Just know that your idea is always a trade secret to start. You should protect it, and we're going to go into how you do that right now. Under the North Carolina Trade Secret Act, trade secret is business or technical information that derives commercial value from not being generally known or readily ascertainable. I have heard from a lot of chefs that a recipe is not truly a trade secret because a good chef can taste your dish and figure out what's in it and how you made it. So, if you have a restaurant, a lot of restaurants have their recipes as a trade secret. Maybe that's not protected under North Carolina law because it's readily ascertainable. If you've ever heard the word reverse engineer, which is where you take something that someone made and you kind of take it apart and figure out how they made it, that's reverse engineering. That is not illegal. So your trade secret has to give your business an economic edge because nobody else knows what you did, how you do it, and they can't figure it out on their own. The other part of a trade secret is that you have to use reasonable efforts to maintain its secrecy. And what those are is going to depend on what it is and what your situation is. So what's not protected under trade secret law? There's no commercial purpose to it. It doesn't really matter to your competitor if they get it. You didn't keep it secret, so it's really generally known. Somebody else figured it out, or something that really would have been a trade secret, but you didn't take reasonable steps to keep it secret. I had a client call me. She has a retail store that also makes some baked goods to sell. And one of her employees left, and she was pretty sure the employee took a copy of the recipe book. And I said, well, okay. I know that gives you a competitive advantage because you've tested these recipes. You've tested how to make them in a commercial kitchen. You know the pricing. You know the steps. You know how to be efficient. How did you keep it secret? She says, oh, it was just in a notebook under the counter, and it's an open kitchen in the retail so people could see us doing it. And I mean, a customer could have even walked behind the counter, reached behind the counter and taken it. I said, well, you haven't treated it like a trade secret. She says, well, the only secret place I have is the safe. And I don't want to give all my employees that are baking the combination to the safe because we keep the cash in there and we keep, So I told her she needed to figure out somewhere between those two extremes how to keep her trade secret secret. Is there maybe a lockbox that you only tell certain employees where the key is, or you keep it in a cabinet at the back of the store that's closed so at least the customers aren't able to see it. You could have your employees sign a non-disclosure agreement. So you need to be aware that your trade secret is only as strong as what you do to keep it secret. Some things you might want to do: password protect files, lock things up, have limited copies of sensitive documents or number them so you know who gets them and they have to sign them in and out. Some things you might not keep electronically. Be careful who you tell it to. Make people sign non-disclosure agreements. If you're sharing your way of doing something with someone, maybe you give them a license and you limit what they know and how they use it. I can't tell you definitively what you need to do because it depends what you have, what your situation is, what your physical situation is. I can tell you, some law firms have computers that are not linked to the internet that keeps all their trust account files on it for security. That's something. Just consider, maybe you keep things on a specific hard drive or on one computer in the office that nobody has access to. Are there any questions about trade secrets generally and not your specific trade secret? Okay. We're going to move on to patent rights. I am not a patent attorney. I have many colleagues that I can refer you to, so I'm going to give you information. I want you to be able to recognize a patent, understand what the rights are that govern it, but I will not be able to answer a lot of patent questions. If you have a patent and you need more information, email me and I will connect you with a patent attorney. Nathaniel may have some he works with as well. So as we talked about at the beginning, a patent is a limited monopoly we grant to an inventor to give them the financial incentive for creating the invention in the first place. What you get in the patent is the right to exclude others from making, using, selling, or importing your invention. You don't have to manufacture it yourself. But you can have a patent, never market it, never sell it, and just sue other people who infringe your patent. You are the only one that is allowed to make it. You can license that, which is from your right, but it really is the right to prevent other people from making your invention. Patents are processes, machines, article of manufacture, composition of matter, which is where you take two things, combine them, and it makes something else, or an improvement on any of the above. A patent is not something abstract. You have to tell the patent office the best way to manufacture or create your invention or your composition of matter. So it has to be something physical. Purely mental acts, pure math equations, things like that that are unapplied and abstract are not protectable by patent law. To register a patent, it has to have utility, which means it has to work. It has to be a working model of something. It has to be novel, which means it's new. It's not anything that's already described in any patent that's already been issued. And it has to be non-obvious, which means if there's someone who's a practitioner in your field, they wouldn't be able to look at something and go, oh yeah, I could have done that. How all these interplay is you get your idea, you search all the pre-existing inventions and patents that have been issued in your field, and the patent examiner is going to go through these three criteria and determine, based on what's already been filed, have you met these criteria? And someone in the art of patent has to decide whether it's non-obvious or obvious. Patents last a long time, but realize that the clock starts running from your filing date and not from the date the patent issues. And it could be years while your patent goes through the examination process. You're going to draft it, you're going to submit it, they're going to have questions, you're going to give clarifications, and that's all federal government, very slow. But you do have a good bit of time to be the only one that can manufacture and sell your invention. So patents, patent process. Make sure your invention is patentable. It's not too abstract. It's not obvious. It's novel. Patent attorney can help you with all of this. Part of making sure it's novel and non-obvious is to make sure you haven't told anybody what it is prior to filing with the patent office. There's certain, if you're not quite there yet with I've reduced it to practice. I have a working model. I can describe my process in detail. But before you file it, this is like your biggest trade secret ever in your business. And they're really strict about how many people you've told. There are people that have lost the ability to patent things because they talk too much at a cocktail party. Other people, research the idea and publish something before the patent got filed. So I cannot emphasize enough that patent is a trade secret. Don't tell anybody unless you have a non-disclosure agreement or a confidentiality agreement until your patent application has filed. Eventually, that patent application will become a public document, but not until it has gone through the process. It's also very expensive to file a patent. The search fees could be $10,000 just to make sure you're able to file it. And then there's fees all the way through the process and maintenance fees. Questions on patents? Okay.
If anybody wants to come off mute for a question, go ahead. You don't have to type it in the chat. Come off mute when she asks for questions and throw your question out there. There is nothing in the chat at this time, Donna,
okay.
By the way.
We will move on. So as you can see, copyright really protects the arts. As I said, it is a right that was protected in the Constitution. So what the Founding Fathers envisioned was what we consider the traditional arts: a book, a sculpture, a song, the sheet music, dance, drama, architecture, photography. They didn't have that then, but what we've done in the modern era is also add things like software. Websites really aren't protected by copyright. I can go into that a little bit later. So when we talk about copyright law, we have shoehorned software into that. Sometimes software, you can patent it. That's harder now than it used to be, just because it's hard to find something that's new and novel and non-obvious in software. And also, when you submit the patent, you have to disclose a lot of how the software works. And so a lot of people don't want to get the patent and have a short time where they're exclusive. They'd rather protect it by either trade secret or copyright. To have copyright protection, you have to have an original work of art that is, quote unquote, fixed in a tangible medium. And it has to be created by a human. There's actually some case law that says photographs taken by, I can't remember if it was a chimpanzee or a gorilla, could not be copyrighted because it has to be a human author. Originality, an original work of art, it has to be a tiny little bit of originality. So these are a bunch of cartoons. The one on the left is called Stickman. And the artist drew this stick figure in a bunch of different positions, doing a bunch of different activities. The artist on the right also had kind of a stick figure creation, and there were hundreds of these by each artist, and some of the activities overlapped. And the artist on the left sued the artist on the right and said, you're violating my copyright because you're too close to my stick man. And people I have the right to make and sell this. But the court found that you have the right to express your own version of most ideas. And they found the idea of a stick man holding a peace sign or throwing a frisbee could be expressed by both of these artists at the same time without infringing the copyright. So what you really need to know about copyright protection is that it protects your expression of an idea and not the idea itself. And that's why we can have so many different versions of the Madonna and Child, or a bowl of fruit, or a photograph of a building. You and I could be standing side by side and taking a picture of the same building, and we would both have an original work of art. So the originality component of copyright law is very small, which is in contrast to the originality, new, novel, non-obvious, and patent law. What is not protected in copyright? Big ideas, big discoveries, natural phenomenon. Again, abstract things that we all need. A fork cannot be copyrighted as a sculpture because it's utilitarian. There's nothing the design elements of it can be, but the functionality can't be copyrighted. Facts, forms. So, the white pages in the phone book are not subject to copyright because there's really no other way to express, let me look somebody up by their last name, here's their address and phone number. A lot of forms are not copyrightable because there's really nothing creative in how you're collecting information. What do you get from your copyright? Remember, patents, you have the exclusive right to manufacture, sell, license, import your invention. With the copyright, similar. It's a bundle. You have the right to copy, distribute or sell, display, if it's a work of art that can be displayed, modify or create derivative works, and I'll go into what that means on the next slide, perform it, or if it's a sound recording that's copyrighted, to publicly play your recording. So that's why if you own a bar or restaurant, you can't just play the radio necessarily in your business, because those are the right to publicly play those is owned by the artist. So that's your bundle of copyrights. A derivative work is where you take your original work and modify it a little bit and then have a second copyright in there. This is a really hard question to answer. Is this a derivative work, or is this a new work that I just saw your work and had my own idea how to express it? So this is, on the left, is an AP photograph taken of Barack Obama while he was campaigning. And it was widely used. It's owned by the AP. The photographer was an employee of AP, Associated Press. And it went viral and people were using it all over the place. An artist named Shepard Fairey created this poster where he painted the picture of Obama, but it was based on that photograph. And the AP sued him for copyright infringement because one of your rights under derivative works, you have the right to make a derivative work of your work. Sometimes that means you translated it into a different language, or reprinted the book, or Andy Warhol and his soup cans. Each one's a little bit different, but they're based on the same idea. Is it a derivative work or not? What the court is going to look at is this transformative? Is the poster a different use than the photograph? Does it provide new insight? Is there commentary? Is there analysis? This particular case settled before a ruling was held, but a lot of copyright lawyers think that this is a derivative work, that the poster is so transformative of a news photograph that they can coexist without copyright infringement. Thumbnails are a derivative work that is held not to be copyright infringement, that if you have a website and you have thumbnails to click on things, that doesn't steal from the original work. In business, one of the big copyright issues is who owns the work when you hire someone to create something for you. There is a provision in the copyright statute called works made for hire. And if you're an employee and you create something within your job description, the works made for hire doctrine says your employer owns that work. So if you have a graphic designer, a web designer, copywriter as an employee, all their work automatically is owned by the company. But most of us go out and hire a graphic designer to make our logo or draft some content for our brochure or even write materials for a conference we're going to give. Those works are not covered by the works made for hire doctrine. It only covers the things on this slide. And as you can see, maybe an instructional test, maybe an atlas or translation might be something you actually use in your business that would be automatically covered by the statute. But in my experience, most of my clients that go out and hire someone to create something for them, they take stock photos for the website, they design a logo, they design the website, they lay out brochures. All of that you don't own, even though you hired someone to do it for you and paid them for it. Copyright vests in the author at the moment they fix it in a tangible medium. I took the picture, I saved something on my computer, even in the cache, not even on the hard drive or a disk. You recorded the dance steps, you painted the picture, that you automatically have copyrights in those works. So as soon as I create your logo, I own it, even though you commissioned me to do it. Also, if you are working with a friend or two businesses are working together on something, you each own an equal right to the copyright. You can both go out and sell it independently, but you have to account to the other person and they get to share in it. So if you are doing collaborative projects and you want to control who can do what with it, you're going to need an agreement up front. If you have hired a graphic designer or someone, you just need a written work made for hire agreement that says, I'm hiring you to do this. As soon as I pay you in full, you automatically assign the copyright to me. But if you don't have it, it's really murky. And there's an implied license, but we don't like implied things. We want to nail it down. That's a mistake I see a lot of business owners making, where you hire someone to do work for you and you didn't nail down that copyright. Copyrights last a very long time. This is something right now, items from 1923 and before are in the public domain, so almost 100 years ago. We've changed the duration and the way copyrights work several times. So originally they were good for 28 years, and then you could renew them for another 28 years. You had to put notices on them, and if you didn't have a notice, you'd lose copyright. So as these changed between 1923 and 1964, you have to really research, and it's very difficult, the circumstances under which the first copyright was granted, and was it renewed? Were there notice issues? Were there publication issues? And it's frustrating. The companies like Disney that had characters from the early part of the century kept lobbying Congress to extend how long a copyright lasts. And that's why they are so long right now. And I would argue personally that this a little bit disrupts the purpose of the copyright in the Constitution, which was to give the author some initial ability to get economic value for their work, but then let it go into the public domain and let other people take off from that idea and make their own expression of it. But here's where we are. So you don't have to register a copyright. Your bundle of rights automatically attaches when you're, fixed in a tangible medium. But if you don't register, it's not worth suing. When you register, you can sue for infringement and get statutory damages, which says, if it was this kind of infringement, you get this kind of damage. If it was willful, you get much more damages, and you don't have to prove your actual economic loss. You can get attorney's fees. So yes, you have rights just by making your stuff, but they're not worth that much unless you register them. To register, there's a form you fill out, submit it to the Copyright Office, which is in the Library of Congress, and you provide a sample of your work, and your work actually goes somewhere in the Library of Congress, which is kind of cool. The forms are different for different kinds of work. So there's one form for text, there's one form for video, there's form for magazines or serial publications, there's audio visual one. So you'll need to figure out which form to fill out, and you can do it all online. You don't have to put a copyright notice on your work. You've probably seen them all over the place. It's the C in the circle, the year of publication, the owner name. I encourage people to put it on anyway to signal that you are serious about your work and you're going to pay attention if you're infringed. It used to be required, and like I said, whether you put a notice on or not had a lot to do with how long your copyright lasted. It doesn't matter anymore.
Can I ask something related to that real quick?
Yes.
There's also a few questions in here. If you want to address them, let me know. I just want to say, you don't actually have to have filed a copyright, trademark in this case, to put the symbol there. Is that right?
For the copyright, no. For trademark, you can put the TM for any trademark, but until you get all the way through the federal registration process, you cannot use the R in the circle.
Okay. But for copyright, technically, just making the work, if it is copyrightable, you put the copyright symbol, and it is technically it's copyrighted. It's just not been filed. Is that correct? Okay. Correct. Do you want me to have one comment and two questions?
Yes.
All right. This one is interesting. This is from Crystal K. She says she's studying law, and she sometimes read about the Creative Commons. What part of the IP category does that fit in, and kind of what is it?
Creative Commons is a company that marketed to artists and gave them a platform to commercialize their art and license it under certain circumstances. So it's like a clearinghouse to connect people that want copy for their like if you want to go put pictures on your website, don't right click, because you'll get a letter from Getty that says, oh, you didn't know this, but this was ours, and you now owe us $5,000 in licensing fees because you can't use it. So they wanted to create a safe place where artists could put out their work and business owners could get access to it easily for free or for cheap. So it's kind of a marketplace to match people who want art with artists. And you have to go in there and read the terms of each individual work as to how you can use them. I've had clients that made labels based on work in a site like that. And then when we read the fine print, you could only print that image 150 times, which kind of defeated the purpose because we wanted to make more than 150 bottles of lotion. I don't have it in this site, but on Flickr one time, I got an image that said all the different social media explained. So it'd be like Pinterest, here's a picture of my donut. Foursquare, I checked into the donut shop. Google, I'm looking for employment at the donut shop. And I read the terms of the license. It said I could use it for educational or nonprofit uses. All I had to do was give the artist credit. Well, the artist's name wasn't anywhere. And so I ended up just putting his Flickr handle on the slide because that was all I had. So that's what Creative Commons is. And it's licensed. Sometimes you pay a small fee, sometimes it's free, but you have to pay attention to the specific terms of each work you're using. Did I answer that whole question?
I think it does. It's its own organization, kind of, then.
Yes.
Okay. What about this one? It says, can you register something like a tagline?
All right. Taglines and titles and names of songs are not considered original enough to register as a copyright. Depending on how you use them, and I will get into that later, you might be able to register that as a trademark.
And what would make it worth doing?
I'll get to that when I do the trademark law.
All right, then. All right.
Okay. So go ahead.
So if you have a novel, a book or a children's book, if you can put copyright on it, or if the ISBN number, if you get one of those, is that protected?
You can put copyright on there. I would register the copyright in a book so that if somebody infringes it, you can sue them and get some actual money.
So
but
the
ISBN number is completely different than copyright. That's about like publishing and marketing and having people be able to find your book and sell your book.
Okay, so that's not protected. Okay, so get a copyright, put the symbol on there, and then register it.
Right.
Okay, thank you.
Sure. So infringement is proven by circumstantial evidence. You have to prove you have other work, took original elements of your work, that they had access and substantial similarity. What happens if you sue somebody for infringement? You can get profits. You can get an injunction, which means the court says the other person can't sell the t-shirts or whatever it is. If they are being imported, you can get customs to impound. If you're not registered, first of all, you have to prove that you have a valid copyright, which is harder to do if you haven't registered it. And you have to prove what your actual economic damages are, which may not be that much. But if you get statutory damages, you could get $200. Oh, I must have heard your song somewhere. I didn't really realize I know it. And I incorporated some of that into my music. You can't prove that they did it willfully. You could get $200 per instance of infringement. If you prove that it was willful, intentional, like you could show they had access and they copied, you can get up to $150,000 per active infringement. So that's part of why it's so powerful to register. A lot of people have very small amounts of works in their business that they are going to want to go through the headache of copywriting. But people who their business is creative works, photographers, artists, you often have a decision to make about, I think the registration fees recently went up to $50 each. And if you're an author, you have 3 or 4 books, that's not a big deal. If you're a photographer and you have thousands of images, that's a big deal. So often people have to just make a business decision about which ones to register and how to protect their work. And that's a tension in a creative business all the time. All right. I talked about just because you can right click doesn't mean you should right click. Remember, every image you see on the internet is something that has been fixed in a tangible medium And unless you go through when was it created, was it before 1923? Is it in the public domain? Is it on a website that's offering it to license it to me? Did I pay for it? There is a lot of misinformation surrounding copyright. If it is on the internet, I can use it freely. Absolutely not. Getty and Reuters, and there was another one recently, own and license a lot of the photography and artwork that is on the internet that people try to use on their websites, on their newsletters, in their marketing material. And if Getty finds you, and I use Getty generically because they're one of the biggest actors, they will send you a cease and desist letter. They will say, here's our catalog number. Here's the image. Here's a copy of your website where you're using it. We don't have any records of a license. $5,000. Thank you. So just the same way, you would not go to the public library and cut out a picture from the gardening book to put on your spring newsletter. Like, clearly, you're not going to do that. Don't do that on the internet because you just push right click and it's really easy. Some people say, oh, I only use 10% or 5%. I can just copy it because I didn't use a whole lot of it. Not true. There's a case where Gerald Ford wrote like an 800-page book after he left the White House and he pardoned Richard Nixon. And there was going to be an excerpt of it in maybe Reader's Digest, maybe Time Magazine, I can't remember. And the chapter that was leaked to them, was sent to them to publish, got leaked. And somebody took about 3 or 4 paragraphs out of the book and published it. And they said, oh, it was an 800-page book. I took 4 paragraphs. That's not infringement. It's, less than 10%. Well, the 4 paragraphs they took were talking about what was going through Gerald Ford's head when he decided to pardon Nixon. And the court found that that was the #1 reason people were going to buy that book. And it disrupted the market for the original one, and therefore it was copyright infringement. We talked about it's too old to have a copyright. Not necessarily. There's no notice on it. I can copy it. This is a big one. If I don't charge for it, I can use it because there's an exception for educational and nonprofit. I'm going to go into why that's wrong on the next slide. I can copy it if I give the author credit. Not necessarily. Sometimes that'll work. So what I'm getting at here is what we call the fair use defense. There is a part of the Copyright Act called the fair use defense. And what this is geared toward is using a small amount of work for purposes of news, commentary, analysis, satire, and people, I think, overuse the fair use defense. Next slide is going to be fair use defense. So to be safe, what do? You create your own content, you hire someone to create your own content, and you get a work for hire agreement. You make sure it's in the public domain. The US or state governments cannot own a copyright in something. So I often go to the Copyright Office and see what materials they've provided on copyright. Put that on my slides because it's created by the US government, so it's okay. Is there a question or just somebody? Ask permission, license it, go to one of these sites that is like Creative Commons or Flickr, or is a place for you to license for a small fee artwork. All right, so fair use is where you copy on purpose someone's copyrighted work for one of these purposes that's listed. But what this means is, you had access and you copied it. That's copyright infringement. And this is a defense. So if you're arguing, well, it was fair use, you're admitting you had access to it and you copied it. But there are 4 factors: purpose and character of the use, the nature of the original work, how much you copied, and the effect on the marketplace. And those are a balancing act that a judge is going to look at all of those factors to figure out if what you did really was fair. You know, you took the whole magazine article because you're a college professor and you didn't want your kids to have to buy the whole magazine. Probably not. You know, when I was in college, that was the age of Kinko's, and you used to go pick up your materials from Kinko's where the professors had like pulled all these things and had them copied into a packet for you. And as I was in college, that was becoming rarer and rarer because it really wasn't fair use, because it completely destroyed the market for some of those books and magazines and materials. It is very, very hard to balance those factors as a layperson. And at the end of the day, only the court is going to be able to determine if what you did was actually a fair use. So be safe. Create it, hire it, go to a site and license it, ask permission. It's so easy these days to get yourself in trouble, but just remember, if you see something on the internet, somebody created it, pretend it's the book in the library, you know, don't go copy it, cut it out, use it yourself. Is anybody here interested in self-publishing? I know we had one author. I'm just going to say that a lot of people publish their own books now. It's kind of the wild, wild west.
Yes,
so,
I'm interested.
Yeah. Make sure you read the contract and you understand what you have to do and what the publisher is going to do for you. Make sure you know how much you are paying them, whether it's upfront, whether it's royalties. And I will say the largest problem I have seen with self-publishing is distribution. Used to be you went to a publisher and they had editors, they had people that laid it out. I've seen some self-published books that the font they use and the way they laid out the chapters, it's very hard to read. Those used to be the services that the publisher provided. And then who's going to distribute the books? You know, is it just going to be on Amazon? Are you going to get it into a local bookstore? Will your publisher help you, or is it all on you? Just be aware that those are the issues. Does anybody have specific questions?
Yes, I do.
Go ahead.
Can you hear me?
Yes.
My name is Nikish McClellan. I am an architecture teacher, and I apologize for being late. My question is about lesson planning and protecting my intellectual property with lesson planning. Do you have any advice as far as that?
I don't on the spur of the moment. I mean, if you're creating a syllabus and you're handing it out to your students, you know, that's not a trade secret. It's probably, it might be original enough to get a copyright on. It might not be, but then you're going to have to go out and find who's using it. I think you just, those are real hard to protect.
Okay, so let me clarify. I work for myself, and I work at an after school program, and they hire me as a vendor and a consultant to teach and introduce architecture to their students. Before, I used to put my stuff on their lesson plans, but then once I got incorporated, I put all of my intellectual properties on my lesson plan with my letterhead and my logo. The newest thing is sharing, because when the school or the after school program has an inspector from the city to come and look at to observe.
All right, let me stop you right there. That's really specific to you. I can tell you should probably license your material to the school and put rules and regulations around how they can use it, how many people, how many copies, that kind of thing. But if you want to get in touch with me after the seminar, we can talk about it more in detail.
Absolutely. Thank you.
Okay.
All right. I have a question.
Yes.
What about, I wasn't sure what you said about online. If you're offering an online course with your materials, how do you protect yourself with that?
Same way. You start the course by saying, this is my proprietary program. You are taking this course for your own personal knowledge. You can't use this to teach it to other people. You can't give it to other people. And you're gonna stop the honest people that don't realize, oh, I took this class, I can't share it with all my friends because the author worked really hard to develop this and, you know, they should get paid for this. Mm-hmm. I see it a lot, people that have things like how to code for a medical office more efficiently. It's like you teach it to that person, they can use it just for the doctor they're working for. They can't teach it to the rest of the staff. And they can't take it to the next doctor. Again, the honest people are like, oh yeah, that makes sense. And the dishonest people, we're going to steal it anyway. It's hard though, because it's abstract, it's online. You can't necessarily control it, but that's the best way I've come up with.
Okay, thank you.
And put copyright on everything. Let them know you're serious. This is my stuff. Proprietarily owned by, you know, whatever the company name is.
Mm-hmm. Okay, thanks.
All right, here's my favorite thing, trademarks. I saved it for last. This is my jam. Trademark is anything that identifies your business to your consumer. So you remember way back at the beginning, I told you patents and copyrights are in the Constitution and the purpose is to reward the inventor and the artist. Trademark is a completely separate body of law. It is a consumer protection law. And it is making sure that when a consumer wants to find a specific good made by a specific person, they're not going to get confused. So you can see we have the word Pinterest. The word itself is subject to a trademark, and the way they wrote it in the red and the print, the cursive. The Apple symbol, the slogan, packaging, that Coke bottle, you all know that's a Coke bottle just from the silhouette. That's a registered trademark. The Old Spice jingle, the MGM lion, those sounds are trademarked. You can trademark a color if the color has no function with the product. So Owens Corning fiberglass, they tinted it pink on purpose so you could walk in and say, oh, that's Owens Corning. That yarn has a fragrance. Again, yarn doesn't have to have a fragrance, but they made it a fragrance. And now you know that yarn is made by, I don't even know what company that is. And the restaurant is subject, that's a trademark. Those stripes, that's a TGI Fridays. If you're old enough to remember the photo kiosks where you drove into a parking lot and you dropped your film off and you came back an hour later to the other side of the building, you picked up your pictures, those little photo kiosks were registered trademark. So anything that identifies your products or services to your customer is a trademark. All right, somebody asked me about slogans before. So this is a really hard concept. I'm going to do my best to explain to you when what you're doing is not a trademark. Sometimes people have slogans for their business, but they don't use it on the actual product, or they don't use it in connection with their service. So I have a law firm named Legal Direction. I have a logo. I also have lip balm that when I go to trade shows or I sponsor things, you know, I have a tent at the golf charity exhibit, I give out lip balm. It has Legal Direction on there and my logo. That is not using my logo as a trademark because my goods and services that I sell is not lip balm. So just because you have put something on your promotional product, that's not really your brand. That's a promotional product. So if you have a shirt, you need to have the name of your company written on the sleeve, written on the tag, sewn onto the front, like, the alligator or the polo horse. A lot of people have slogans that they use with their business, but they don't have the product and the slogan together. And if you don't have it very closely associated, you're not technically using it as a trademark. I have a hygienist, somebody that sharpens instruments for hygienists, and her website, we have the trademark on there, but she has uniforms that her employees wear that have the name on it. She wanted to register the trademark on her clothes because she has her business name on her clothes. That is not a trademark because she's not selling, Acme Hygienist Services t-shirts. Hard Rock Cafe has every single bit of merchandise in their cafe is a registered trademark because they are selling those items. But if they just had the waitresses or the waiters wear a shirt that said Hard Rock Cafe, they could not get a trademark for shirts because they're not selling shirts. That's not their product. Their product is restaurant services. Does that make sense to you guys? Because it's a really hard abstract concept.
The Hard Rock Cafe part did not make sense to me. I'll go ahead and say it.
So if you go to your local neighborhood bar and those waiters and waitresses are wearing a t-shirt that has the name of the company on it, but they don't sell t-shirts with their name on it as merchandise. Mm-hmm. That's not a trademark for t-shirts. Their trademark is restaurant services, and they're promoting their services with a t-shirt, but you can't buy a t-shirt from them that says, Joe's Neighborhood Bar. So the trademark, they can register it for the restaurant, but they can't register it for t-shirts just because they put their name on a t-shirt.
But the logo on the t-shirt is trademarked. That part of it.
Let me back up and say one more thing. You register a trademark and you specify a specific good or service connected with your trademark. So if your service is, I'm a restaurant, you can't register a trademark for a t-shirt or a keychain unless you're selling those also to your customers. Like the banks have pens, they have koozies, they have hats with the name of the bank on there. They don't sell any of those things, so they can't register a trademark for those promotional products. They register their trademark for banking services or financial services.
So you're saying anyone can print Hard Rock Cafe t-shirts if I wanted to? If I want to print one, I could print one?
No, I'm saying that because they sell Hard Rock merchandise in their restaurant, they can get a registered trademark for t-shirts and not just for restaurant services.
It's marketing. Like for the bank, they have the pens and the stuff and the little piggy banks. That's for marketing.
Correct.
What they really do is financial institution. Hard Rock Cafe, they do food. Unless they decide to sell apparel, then nobody can, anybody can use it. But even if somebody take it, it's free marketing.
Correct.
So the logo is still protected. So you cannot go and print your own t-shirt with Hard Rock Cafe.
I will also say that famous trademarks, and it's a little murky how you become famous, have a lot more protection than just a regular. So, there was a case where a company I'm going to be really clever. I'm going to manufacture and sell Kodak brand bicycles. Because Kodak is a chemical and film and camera company. They don't do bicycles. So they didn't register a trademark in connection with bicycles. So I'm good here. And the court said, wait a minute, not so fast. That is so famous. that if you have Kodak bicycles, the public's going to assume that they branched out into a new venture, and they're going to assume the chemical company made the bicycle and people are going to buy it because the chemical company and they love the camera. You can't do that, but it's really hard to be a famous brand. So in your particular situation, if you put a Hard Rock logo on something, they would come get you. Same with McDonald's. Like, you can't file Mick anything as a trademark.
Mm-hmm. Okay, thanks.
Yeah. All right. So trademark is supposed to identify your company as the manufacturer of a particular good or service. It's how people feel about your product. It's all the goodwill you've generated. And so to give you exclusive rights to use that name with your product and not let anybody else get close to it so the public can find you, there's some restrictions on what you can use as your name and get a trademark in it. So you can't have beer brand beer. Can't have generic. You can't have something like sparkly cleaner. Or lemony fresh cleaner, because those are words that people need to describe the product category in general. Also, they don't really stand out in the marketplace, so they're really terrible trademarks. In general, you can't use surnames. You can't use geographic descriptions of your goods. I know people do. It's hard to get those through. Immoral, scandalous, or deceptive, that's changing a lot because there was a case where a band of Asian American folks called itself the Slants. That was their name. They picked it. And they tried to register a trademark for that. And the trademark office said, no, that's immoral and scandalous. It's offensive. And they said, wait a minute, we're Asian American. We picked this name. We don't think it's scandalous. And we have free speech rights to call ourselves that. And the court said, you're right. So immoral, scandalous, and deceptive is becoming harder and harder in our society today to say, hey, that's scandalous, kind of like obscenities. You know it when you see it. It's harder to find that exception. Can't use flags, government indicia, like the eagle, anything that makes you look like you're part of the federal government or the state government. Name, portrait, signature of living persons, unless you get their consent. And then here, the Olympic name, Olympic rings are covered by federal statute. Can't use them. So the standard for trademark infringement is really mushy on purpose, substantially similar, or likely to cause confusion with an existing trademark. So you don't have to be exactly the same to be infringing. When you're picking your name, marketing's always going to tell you, pick something really descriptive of what you do, because then people will know what your product is. Merely descriptive words are not eligible for trademark, and marketing and legal departments fight over this all the time. You can have something that's suggestive, but not descriptive. I'm going to show you more on that. Something arbitrary. Apple for computers was completely arbitrary. They spent a lot of money getting people to associate that, but now it's a super powerful brand. Something fanciful. Kodak was a made-up word that they put a lot of money in teaching people what it is. So arbitrary and fanciful are your strongest trademarks from a legal perspective. They're the most distinctive. They help you stand out the most in the marketplace. But it takes more money to break into people's minds with words like that. All right, suggestive or merely descriptive. I will be honest with you, I can never tell when I'm reading these cases which way the court is going to come out. So Greyhound for a bus is suggestive of we're going to get there fast. Pizzazz for pizza restaurant was considered to be descriptive. So I really push people to fanciful or arbitrary names if I can, because I think suggestive is really hard to predict when we're filing the trademark, and I want it to go through for you. How do you pick a trademark, brainstorm. What are qualities of my product? What do I want my customers to be aspiring to? Look for the domain name. Like I said, you can have a trademark in different categories of goods and services that are fairly similar. So if your domain name is not available, maybe it's because somebody with the same name in a completely different product category already has that product. But maybe if your domain name's not available, it means your trademark's not available either. So that's not definitive, but that's a marker to look closer. What shows up on online search is when you're searching for your name and your type of service. Is there a lot? The more that's already there, the harder it's going to be to get a trademark approved, because the chances of you being confused with someone else are very great. You can search state or federal databases to see if there's something available. I tell people to think of, what's a hobby they love that's not related to their business? What's something meaningful to them from their childhood? Was it a scallop shell? Was it a treasure hunt? Did we go, have a clam bake somewhere? Use that for a business that's completely unrelated. I love helping people come up with names that are good. All right. We can have, if you want, I can send you these, but here's the places where you can search for trademarks. The U.S. Patent and Trademark Office and the Secretary of State does state trademarks, and I'll get into the difference between those. But Domino's Pizza and Domino's Sugar, we don't get confused that those are manufactured by the same people, because they have completely different markets. They are used for completely different things. They're not sold side by side. So remember, you can have a very similar name for a very different product. Does everybody that wanted to copy this? Because I'm going to move on. If you didn't, we'll get it to you after. Trademark registration process takes forever. You will file a trademark application with either the state or federal government. The examiner in federal right now, they're taking at least 8 months to even look at it. Used to be 3 before the pandemic. A lot of people are working on their businesses during the pandemic, and they got slammed with applications, and they took a lot of money out of the patent office to put in other parts of the government. So they don't have a lot of people. State takes a few months. It's not as long. The examiner is going to examine it and do, is this likely to cause confusion with somebody else? They're either going to approve it or send you an office action, which is a letter that says we preliminarily denied your application. That could take a year just to get to that. It is then, once it is approved by the examiner, it gets published in something called the Official Gazette, which is a newsletter from the federal government. So once the examiner says, yes, it's okay, every other trademark owner in the country can look at the Official Gazette and say, no, I think you're too similar to mine. They can file an opposition. I've only ever had that happen once in my entire legal career, and I thought it was BS, but the client changed their logo anyway, so it didn't matter. Year 5, year 10, and then every 10 years, and you just have to keep using it. So, infringement, substantially similar, likely to cause confusion. What do you guys think? Is this substantially similar, likely to cause confusion? Court said yes. This is a non-traditional trademark. The 3 stripes are Gucci. The one on the right is Gucci. The one on the left is Guess. Court said that customers looking for Gucci shoes might be confused by how similar the Guess shoe was.
I agree, totally.
All right, here are pictures. Excuse the poor photography that I took in the store, and the store loss prevention was following me around. But one of these is a name brand. One of these is from the dollar store. But notice gray bottle, red cap, plumber. in some form or another, prominent on the label. So I think pretty much everything in the dollar store is trademark infringement because it's supposed to make you think it's the same quality as the national brand, and probably not. So here's a play on Ringling Brothers, Barnum Bailey Circus, the greatest show on earth. Utah Department of Economic Development or whatever, greatest snow on earth. And the circus is like, hey, that's our trademark. They're, and the court was like, oh, come on. People can tell you're playing on the circus, and that going skiing in Utah has absolutely nothing to do with the circus. We don't think, people think the circus suddenly opened a ski resort. This is fine. All right. Fair use and copyright. We also have fair use in trademarks. So you can honestly advertise, I fix Ford, I'm Microsoft certified, that kind of thing. You can mention someone else's trademark in your business if it's true. You can also have commentary. And I don't think this video is going to play. This is left over from when I was doing live. But this is a recording by an artist. It's called United Breaks Guitars. I'm going to play. I don't know if it's going to play, but we will try. Do you guys hear it?
Not really. It's not coming through.
So he is telling the story of he flew and United, the baggage guy, just like they made him check his professional guitar, and he was looking out the window and he saw the baggage handler just chuck it down the runway to the other guy, to the point where it like opened up and like tumbled down the runway, and all the passengers are on the plane were like, hey, look at this. If you want to look at it, it's called United Breaks Guitars. That is not trademark infringement. That is commentary. And it was considered to be fair use. So you can, this is where the like United Sucks websites come from. Those are not considered trademark infringement because it's clear that you're criticizing a product and you're not trying to pass off your own product as a trademark. But that's worth a look. All right, come on.
Is it clickbait, though?
That particular one is not. That one's hilarious.
No, but I mean, using people's trademarks to criticize them in social media specifically might be, I mean, it is clickbait. I'm just saying, regardless of whether it's true or not, it's a clickbaity thing to do. Anyway.
I think I have a slide on that. Anyway. All right. So if you think you're being infringed, be careful for your tone. I always say at this point, you can be Jack Daniels or you can be Starbucks. Starbucks has web crawlers that search for their trademarks being used, period. And they have this fancy law firm in New York send a very nasty form letter, and it has a tone of, this is our proprietary trademark and we have an obligation to marshal our resources, and you've got 5 days to stop and you might owe us damages, and it's very scary, it's very stiff, it's like 4 pages long. And one of their web crawlers got a Crossroads bar in rural, I think, Missouri, a town of like 400 people. And the bartender had homebrew craft beer on tap. And one of the customers wrote on the bar's website, "This tastes like a Frappuccino." And that got picked up by the Starbucks web crawler, and they sent a really nasty cease and desist form letter because it's the web crawler. Some person in a law firm just signs these form letters. And the bartender or the owner wrote back this hilarious letter saying, okay, sorry, I keep using the F word, Frappuccino. I've sold 6 pints. I can't imagine anybody thinks it's from Starbucks, and I made, $8, and here's the 6 cents profits for my using the F word inappropriately. And his response went viral because it was such an overreach, stupid letter in the first place. And he reacted to it with such good humor and made fun of them that went viral. And Starbucks took a lot of heat for that. Jack Daniels, on the meanwhile, if you see that picture, one is the Jack Daniels label, and next to it is a book that this guy wrote, Broken Piano for President, based off of the Jack Daniels label. Well, Jack Daniels wrote him a letter, said, we love fans. We're so glad you were inspired by our label. We're so glad you love Jack Daniels, but we have this obligation to police our trademark and look for infringers. And we think people might be confused that somehow you're associated with Jack Daniels. So when you reprint your book, please talk to us. We will pay for you to create a new cover for your book. And that also went viral. And people were like, damn, Jack Daniels, they know what they're doing. Like, they appreciated that the person loved their product. So I just point this out to you. There are a lot of ways to get people to stop infringing your trademark, and tone matters. All right, the last thing I'm going to leave you with is the difference between a trademark and a trade name, because a lot of people don't understand. So if you look at the bottom of this slide, there are a lot of everyday products that you use in your house: Bounty paper towels, Cascade dishwashing liquid, Charmin toilet paper. And as you hear me saying the trademark and the product. So a trademark is always an adjective that describes a product. What you don't see on any of these products is Procter brand detergent or Gamble brand mouthwash. The Procter & Gamble company is a Delaware corporation that manufactures all of these other different products. A lot of small businesses, the name of the company is the same as the name of the product or service. And so your trademark is the same as your trade name. What you use your trade name for is your name that you register at the Secretary of State when you form a LLC corporation partnership. And all they are going to look for is, are you one letter off any name that's already in our database of companies? So, you could be Procter & Gamble Roman numeral 1 in the North Carolina State Secretary of State website. That does not mean you can use that product name as a trademark to market your product or service. So just because your company name is clear at the Secretary of State does not mean you are not infringing somebody else. I am open to questions.
All right, I have a question. You mentioned about the book cover. If I use, what's the name of that place? Fiverr to do my book cover, do I have to, how do I copyright that before it's even made?
It's part of the book.
Okay, so when they do the artwork, how do I protect it?
You get a work made for hire agreement.
Oh yes, you did say that. Okay.
Yeah, that says we created this, but we're going to assign the copyright to you, and then you use it in your book. Okay. But you want them, to say that they're not infringing anybody else's work when they create it for you. That's part of the work made for hire agreement.
Okay. Thank you.
Yeah, one question.
I'm sorry. Yeah. Go ahead.
Yeah. So if I write a blog and in the blog I appreciate a food delivery company saying that their services are very good and they're excellent, and I use some cartoons which I make, some drawings, and I use their logo and everything over there, will it be some kind of an infringement?
No, but I would disclose there's some Federal Trade Commission guidelines on bloggers. So you need to disclose if there was any compensation to you for giving that review. So like sometimes bloggers get free products to review. You have to disclose you got it for free. And then just say, here's my review. So that, I don't think there's a trademark issue. I would just make it clear whether or not you have any compensation or you received anything for that review.
Okay. So the basic purpose is that once I write good reviews, the company might notice me and they might approach me for further blogging.
Yeah, so you just say, you know, I wasn't paid for this. I didn't receive any compensation for writing this review. I'd put it just down at the bottom under your name or something.
Okay. Okay.
My question is similar to Danny's question. I think I'm hopefully pronouncing her name correctly. She put it in the chat. The question about protecting the content you create for webinars such as this. How do you protect your slide deck? So many times the slide deck is made available to attendees or people who didn't attend.
Yes.
Sometimes it's not. So how does that work?
You need to make a decision on kind of under a trade secret provision. You know, my slides, largely information, not a lot of original content there. You know, it's the organization to it. Really, that's my intellectual property. You know, if I were interested in copyright protecting, I'd put a watermark on it so people couldn't copy it. Or I'd make sure the slides that I gave to people didn't have any proprietary information on them.
Okay.
Or I'd license, you know, if I was like, here is how you start a trademark business to help people file their trademarks. And I'm giving like proprietary knowledge. I'd make them sign a license that I'm teaching this to you so you can start a law firm to do trademark law. You can't teach it to anybody else.
Thank you.
I don't see any other questions in the chat. If you have a question, now's the time. Still have 5 minutes technically if you want to throw it out there. Come off mute, give us the question. I do want to remind everybody we'll actually go deeper into trademarks with Donna on the 27th of July. It's called Introduction to Trademarks. Donna, would you say it's a little deeper than what you went into here? Or
it's a little bit deeper. It's gonna I love the trademarks, so I'm always trademark heavy on IP. I don't like to file copyrights for people because I feel bad taking their money because it's pretty straightforward.
Yeah.
But we can go more in depth. It'll be more in depth. But if you can't make it, you've got a good basic understanding of it here.
Definitely. And we're going to talk about social media and more directly into using images and stuff in social media as well, and different legal aspects of that in August. So keep an eye on that. Everybody who's here, I love to see people come back and, keep interacting and networking with us and participating. I see that Patrick Rodriguez is on the call from the SBA. If he's there, if you want to say something, Patrick, go ahead. He joined us. I do see what day is the following. So I'll send in a follow-up email. I will put the links to everything, the follow-up classes. I'll also put links to the information that Donna spoke about. And if you're sharing the presentation, I'll put that on there so people can unwatermarked presentation.
Nathaniel, thanks so much for putting this on and with Donna's help. I appreciate it. going to share this with the rest of the office, by the way, so they can have a little bit of knowledge on this topic, because I think it'll go a long way for them as well. Appreciate it.
Great. Thank you, Patrick. All right, then. I will share an email, like I said, and make sure you see us next time here again with Donna. I love these. This was very interesting, even though I've been in a few now of copyrights and trademarks, and there's always something additional to be said about it, and it is a complex subject. I think you could probably learn a lot by getting in there and doing your trademark, your copyright, just getting in the website, start to dig into the government site. There's a lot of info there as well, lots of webinars, lots of additional information. But I always like to tell people that, I mean, use legal help, especially for stuff that's complex or agreements or contracts. I mean, there's a reason why lawyers study as hard as they do and do what they do. And it's a good investment for your business, thinking about spending $2,000 for some legal advice over the course of a year. I mean, that's not a bad thing at all. So think about that investment and be careful. There's a lot to think about. And to make money, you have to spend money. So join us again later. I don't know if you have anything else to say, Donna. I don't want to cut you off.
No, just thank you all so much. And I will just finish by saying the workshops and the seminars are the hardest things to protect. So I understand why there were so many questions about that. It's difficult, particularly in the Zoom age, in the social media age.
Definitely. All right, then. Thank you, everybody, for being with us. Thank you. Have a great rest of your day, and we'll see you around. Take care.